And the final story we're going to cover today is another one that we wrote up this week, also dealing with the Supreme Court. Another instance of the court refusing or denying a request, rather, to intervene early in the ongoing saga with Illinois' assault weapon ban, or in this case, a municipal assault weapon ban in Naperville. So it's the second time in this exact case from the National Association of Gun Rights, who's the gun rights group plaintiff that's bringing this case. They've tried now 2 times to get the Supreme Court to step in, and both times the court has unceremoniously denied that request.
Yes, unceremoniously, basically silently. There's been no noted dissents. The court hasn't written anything about why it's not getting involved at this stage. The important thing to keep in mind is that these are emergency requests. People call this the shadow docket sometimes, because sometimes the court will get involved on an emergency basis and won't explain itself. This is sort of a way of short-circuiting the normal legal process to try and get the court to do something before it's, your actual turn to ask them for help, right? If that makes sense. That these cases haven't gone through the merits completely yet. They're at the preliminary injunction stage, which is where, this stuff I know gets really confusing for normal people. And it can be confusing for us too, right? As people who aren't lawyers. But the preliminary injunction stage is essentially where you're trying to get a law blocked before it goes into effect, and you're trying to do that quickly. So you're asking for basically unusual. It's hard to call it unusual because this is how a lot of cases go, but you're asking for early relief before the merits of the case have actually been argued technically, even though to issue a preliminary injunction, judges have to find that it's likely the law you're trying to get blocked is unconstitutional. And so there's very few circumstances that I'm aware of where, in the cases that I've watched at the very least as a reporter, where the preliminary injunction ruling doesn't match the merits ruling, even though technically they don't have to, if that makes sense. So you're sort of the way these courts are set up. There's good reasons for these things. Potentially, that maybe we should have a lawyer on at some point to just go through some of this basic stuff. But the only point here is that you're not at the merits level of the case. You're not at the full argument stage with this assault weapons ban case. You're at the stage where the group is trying to get a block put on the law before you go to the full merits discussion. And it seems that the court just doesn't want to get involved at that spot in any of these gun cases, right? The Second Amendment cases, at least. Now, the complication here. So first, from that, I would say you can't draw too many conclusions off of what's going on with this stuff. Has the court changed its mind about the Second Amendment or the Bruin test or any of this stuff? I don't know that you can make a solid conclusion just based off of what they're doing with these emergency requests. At the same time, they have granted to the government in the ghost gun ban case out of Texas. The ATF, the rule that they put in place to administratively ban homemade guns without serial numbers, or the sale of unfinished gun parts, essentially. That rule has been found likely unconstitutional, and there have been preliminary injunctions put on it. And the court has stepped in when the government has requested an emergency stay on those rulings to keep their administrative rule in place and enforcement in place while the case goes forward. And they've done that twice. There were some noted dissents on that. It was, I think there were 4 conservatives who dissented in that instance. I think it was Roberts and Barrett who didn't, right? If I'm remembering it right. But again, even that, while I'm sure it's well, it's like understandable that gun rights advocates would be upset with the court for issuing those emergency stays, but not issuing emergency injunctions in like the New York gun free zones cases, or the assault weapons ban case out of Naperville, Illinois. I don't think that any of this tells you how the court is going to go on the merits on any of these cases. Is like the ATF one, that's not a Second Amendment case, first of all, or hasn't been adjudicated that way. At least there are some Second Amendment claims in there, but it's more of an administrative powers case. And I don't think that the court, if you look at their record to this point, they've been very skeptical of administrative power. If you look at like the EPA case from last year, it was a pretty big blow to administrative power. And so I would be surprised if any of these have more than a procedural justification for why they're doing this. They seem to want, in the Second Amendment cases, I think they want full records to be developed before they take something. They just handed down Bruin, last year. And so they're getting a lot of requests to follow that. And I think they want the lower courts to go through the entire process and build a full docket before they actually do anything on it. And keep in mind, they are doing a Second Amendment case. Rahimi that I mentioned earlier, they're literally doing a Second Amendment case right now. They may not want to take a bunch of Second Amendment cases until they get through that one, and probably through the other ones that are directly implicated by that one, like Range and Daniels. So the other thing to it, right, is really they've said a little bit, right? In the New York case, you had Alito and Thomas issue a concurrence, meaning that they agreed with not getting involved at the stage that they were asked. But they issued a concurrence where they called the ruling against New York's law thorough. They basically praised it and told the Second Circuit that they need to hurry, or at least not delay things. But like judicial timelines are very stretched out. Like I understand why people get upset about this, because they view like, well, these assault weapons bans are going to go into effect while we're waiting for the courts to get through this process. And we all think that this stuff's unconstitutional. So the court should just step in and say it is immediately. And sometimes the court will do that with things, but most of the time it doesn't, on a whole variety of things. And it doesn't mean they're not going to, but that's just where I'm standing. And I think the main thing, they said that in that case, but what's stronger evidence to me that this isn't how they're handling this is an indication of where the court is at on the Second Amendment today, or that they've changed how they view the rights in the case, is the silence. You don't see dissents from the conservative justices, especially like Thomas and Gorsuch, who had previously been open to issuing dissents when the court rejected certain cases. And you don't see them talking about the Second Amendment being a second-class right in dissents. That if you start seeing that stuff happen, that's when you would think that maybe something has shifted on the court. Or, just wait until they issue Rahimi and see what they say there. That'll give us real insight into what they actually think, because it'll be their actual written opinion.
Right. No, I think it's a good point. And just to kind of put a final point on it, that Alito and Thomas concurrence, you're right. On the one hand, they praise the lower court ruling while saying they're not going to get involved. But Alito specifically wrote, like, I understand us not getting involved to mean we respect the Second Circuit's procedure. Yes. So they literally spelled out like, hey, this is about is respecting lower court, due process and procedure. So the fact that they said that in that one case, I think it's fair to say that probably similar logic applies to some of these other cases. And to your point, you can't really draw too much conclusions on how they view the merits of these cases.